afternoon, everybody, and welcome to the first annual Research Symposium on International Commercial Arbitration. This year, we have thought of making an addition to our usual program, all right? Because we were training the students to compete during the weekend, actually. So tomorrow and the after tomorrow, we were training all the arbitrators in order to make, as Professor Brand said this morning, the good questions to them. But the academic side was not really developed. And so, with the other partners, we said, all right, why we don't organize a research symposium? And this is the reason why this year, besides the round table, we have also this event. So first of all, I would like to thank all the speakers. Some of them accepted the invitation despite the short notice, so thank you very much for being here with us. We will have also a speaker from UNCITRAL connected with us through Skype, because unfortunately she could not fly to Bahrain. And obviously I would like to thank Dr. Pasquale and my colleagues at the College of Law for supporting me, Professor Brand for his continuous advice, and Ms. Catherine Funk, because she has been supporting me from an administrative perspective. All right, so I will not take too much time, and I will just invite on stage Dr. Mona Suri, RUW Academic Vice President, for her welcoming remarks. Thank you.
Thank you, Dr. Maria. Dear Professor Brand, Dr. David, distinguished speakers, arbitrators, colleagues, and students. On behalf of Royal University for Women, I take this opportunity to welcome you all to this first annual Research Symposium on International Commercial Arbitration, which is organized by the College of Law at Royal University for Women. Just giving you a brief history about education in Bahrain. The first higher education institution was opened in Bahrain in year 1968, and many public and private higher education institutions have followed since then. In Bahrain, the Higher Education Council oversees the higher education, and in 2014 they came up with the first national research strategy, which was based on the Bahrain Vision 2030. This was primarily to encourage research and development in universities and to create a platform of knowledge-based economy and improve research in higher education, and also to contribute to the overall standard of teaching and research in Bahrain. As per their guidelines, it is important that whatever research is happening in Bahrain should focus on building and developing scientific capacity and skills through recruiting and training postgraduate students in all domains. Also contribute to the transformation of the Bahraini society into economy of knowledge, knowledge based on innovation and creativity. Create income generating applications that contribute to diversification of income in the Kingdom of Bahrain, and to cooperate with the local, regional and international scientific research centers. In order to facilitate this whole thing, they also made it mandatory that each university must spend 3% of their total revenue on research and research-related activities. Talking about the research at RUW, we were established in the year 2005, and we are very proud that we are the first private university in the Kingdom of Bahrain to receive the local HEC accreditation and also the international accreditation. Our mission is to realize our commitment to teaching, learning, research and service through the activities of all the members of the university. We attempt to instill research as an essential function of the institution, and the conduct of research, scholarship and creative activities is at the core of Royal University for Women's mission and vision. This is an important strategic goal, and the goal is to encourage high impact research output from our faculty members. And we know that this would be achieved through enhancing the research culture and research related activities. Accordingly, RUW Research Strategic Plan has been developed in order to ensure consistency and rigorousness of research at RUW. The basic priorities and initiatives are, for example, to promote competitive research both at regional and international level, to enhance the leading role of women in research, to facilitate the interdisciplinary collaborations, to encourage effective communication and dissemination of research results, and to strengthen the link between RUW and private and institutional stakeholders. In order to actualize these goals, many good practices which have been related to research have been carried out at RUW. We encourage faculty members to increase the volume and quality of research with the research target of 1 research per faculty member per year in a reputed journal. A research forum was established in 2012 where faculty members, they present their research amongst their colleagues, the finished research or even the research which is in progress. We have specific college-based research themes which are consistent with the national strategy of Bahrain. For example, in College of Law, the research themes are to have something related to national, international and comparative legal studies, Arab regional legal studies, and also women and legislation. In addition, each college is also identifying the multidisciplinary research themes. For example, again, if I quote for the College of Law, it is basically law with business or law in art, design and architecture. Further, RUW also developed its own scientific research council which is overseeing the research activities at RUW. We are working closely on research projects with the Supreme Council for Women, various ministries and Civil Government. Internationally, we work with our international partners like West Virginia University, Dar al Hikmah University, University of Bangor for various workshops, conferences, and in addition, we also host various Fulbright scholars on a regular basis to share their experiences related to research with us. We also organize a biennial international conference on women and society every 2 years, and each college are required to plan a conference on alternative years. The first conference of RUW was held in 2016 and the second one in 2018 with the theme of empowering women through higher education. So this first research symposium on international commercial arbitration is an initiative by the College of Law to bring together the practitioners and academics to discuss the current issues pertaining to international commercial arbitration. We are expecting that this particular research symposium will actually culminate into some joint research projects, some research initiatives and linkages with you individually or as a collective body in a very professional manner. And I just hope that the next 3 hours what we have in terms of the various deliberations that we have will actually give us some good ideas about how to conduct research in the field of law. So thank you very much and I welcome you on behalf of RUW for this research symposium. Thank you.
Thank you very much, Dr. Mona. And now I would like to come on stage Dr. Pasquale Boria, the Dean of the College of Law.
Thank you, respected members of arbitral tribunals. I will speak for 10 minutes, which is the time assigned to me. And I think...
With or without rebuttal?
Well, if you want, you can rebuttal, and we'll see it. No, I'm really happy today, and I'm really thankful and grateful to Dr. Maria and Professor Brand, because when we met last year and we came up with this idea of adding a pillar to this amazing program, it took us only 1 year to materialize this and to come up with an excellent research symposium with a high-profile panel. And this shows that again, as I mentioned on the first day of the opening ceremony of this program, universities should be involved in this program because the linkage between practitioners and students go through the university. And this proves also that the vision of RUW College of Law of becoming a center of academic excellence in international commercial arbitration is becoming true. So an architecture with 3 pillars is much more solid and sustainable at this point. And this proves also that RUW is not just a venue, but RUW is a committed partner to the BIS project. And RUW College of Law is here to strengthen the bespoke process. So I really hope that this experiment that we're doing this year in adding a research component to the program will be successful and sustainable. That's why I think ambitiously Dr. Maria and Professor Brand named this the first annual research symposium. I've used my first 5 minutes as an administrator, but allow me to use my 5 minutes as a scholar. Now, international commercial arbitration is not one of my main research fields, but it seems to me that here, the interesting program that you have today will kind of go through and reflect on the dichotomy between arbitration and mediation. And I see here some very interesting words, like modern arbitration. Well, the new Singapore Convention is definitely something modern or futuristic. So I want to talk about the past. And as Michael Paget Joyce knows very well, we share a passion on antiquities. And so, with the only intention of throwing on the table some topics which might inspire a discussion on modern arbitration and mediation, I was just reflecting on the etymology of arbitration and mediation. Arbitration and mediation were both used at the time of the ancient Romans. And arbitration comes from arbiter, which comes from a pre-Roman word, which was arbitere, which then was converted in classical Latin, arbire, which means to go somewhere. And then it evolved in a way that people who go somewhere, they see something and they witness something. And so they are able to testimony or to evaluate facts. Now, the concept itself evolved further, having a connotation of authority. And then the arbiter became the person designated upon free will of the parties to decide the case, as opposed to the iudex, which comes from the Latin ius dicere, so literally to say the law, or to say what is correct, or what corresponds to a legal obligation. Now, after the 1st century for Christ, the arbitration was, after being opposed by the praetores, by the judges, by the members of the Roman judiciary, became kind of codified and accepted as a practice of the Roman proceedings. And the Compromissum was one of the first arbitral agreements in the history. Compromisso comes from 2 words. Cum promissum, which means agree on something and stick to that. So the arbitral proceeding starts to be something on which the parties agree that the dispute is regulated or decided by someone else, a third party with authority, and they commit, because compromissum can mean commitment, to stick to that judgment. The further step was the edictum, so the verdict of the praetor in acting coercitio, which means enforcement. So mediation or mediator comes from, again, the Latin locution in medium iter. So those who walk in the middle, literally. And so it was kind of conceived as a different procedure by which a third party comes into a dispute to help the two parties solve the dispute without the parties necessarily appointing or recognizing the authority of the third party. So, this is my humble contribution to this symposium, and I hope that starting from the very old legal settings of the Romans, you will take this further, discuss about the modern arbitration and mediation, and possibly envisage the future developments of arbitration and mediation. Thanks very much again to all the speakers today, again to Professor Brand, to Dr. Maria, to all the partners of this event. I don't need to name the acronyms anymore. And I wish you a successful research symposium ahead. Thank you. No rebuttal.
But we have still the Q&A. Thank you very much, Dr. Pasquale. And now I will give the floor to an amazing person and colleague, someone it is always a pleasure to work with. He's the only person who replies to my emails within a maximum of 5 minutes, despite the difference in the time zone. All right, and I can tell you that over the past 6 months, I've been sending him several emails, and yet he didn't put myself in the spam, at least not yet. He doesn't need any introduction. Professor Anna Grant.
Thank you, Maria, and thank you, RUW, for adding this component to the program. I do think it's important. I think it matters. When the VIS moot was established, it was established primarily as an educational tool. Now, there were other moots, international moots at the time, that were designed to be primarily competitions. But Eric Burston, who was the real father of the VIS moot, described what he wanted to get out of it, and he intentionally put very few rules in the process. There are lots of moots with very picky little rules, but because he said, look, this is educational process that incorporates a competition, but it's not the competition that's important, it's the education that's important. So to add an academic educational component to this is not only good, it's completely appropriate and the right thing to do. Now, we are at the Royal University for Women with wonderful facilities here, and it is really appropriate that we begin this first symposium with a panel of 3 women. Okay. Now, we didn't go out to choose 3 women. We went out to choose the 3 most appropriate people to speak. And this is, you will see, the title is the first annual research symposium on international commercial arbitration. And then you look and you say, well, wait a minute, this is mediation, right? Well, this is dispute resolution. And arbitration is seated in a larger context. And today's program, both panels, I think help us understand that context, with some presentations directed specifically at arbitration, some focused on mediation, some kind of wrapping their arms around various aspects of this. But I think it's appropriate because you cannot do arbitration unless you think of the context in which it exists. And so often in today's world, you'll have arbet clauses, clauses that are staged, mediation first, arbitration next. And we need to understand how the law is developing to affect that. That's what we're going to do in this panel. We have 3 wonderful speakers. Dr. Dania Paz, Deputy Director of the International Chamber of Commerce in the MENA Representative Office. And it's wonderful to have that ICC perspective on this because the ICC has been involved in mediation for quite some time. And so she can set the stage for us on that. And she's somebody who's not just in the ICC, but she has experience in private law firm. She has experience in in-house corporate practice. She has experience in the academy. So she brings it all together for us. Janet Checkley. If you've been around, you'll know that the training this year is Janet's creation. She has put the thing together for the students, and that is wonderful. She is at the Singapore Management University, which houses the Singapore International Dispute Resolution Academy, CIDRA, and does wonderful programming for them. Most importantly, if you remember nothing else about Janet, you remember that she's a Pitt Law graduate. All right? And then we have coming into us up here in the program, Dr. Judith Nieper from UNCITRAL. Now, Judith is particularly appropriate to represent UNCITRAL in this process because Judith, in one of her prior positions, was with GIZ, the German organization that does work, and for her it was in the Balkans. And before we at CILE worked in the Middle East with BISMUT as a training tool, we worked in the Balkans, and one of the schools we worked with was the University of Belgrade, and the University of Belgrade has developed this amazing pre-moot process, but they always have an arbitration conference preceding that, and that was Judith Nieper through GIZ who provided the funding that helped make that possible. So that we have a panel here that not only is expert at what they're talking about, but has been involved and demonstrated their commitment to the educational process in which they're involved. So it's wonderful for me to simply sit up here and benefit from all of this, but I want to say thank you in advance to our panelists, and with that, I'm going to ask Dalia to lead us off.
It's an honor to be here and to share this panel with all the other co-panelists. And thank you, Dr. Pascual, for hosting us today. And so basically, my presentation will be an overview of the mediation and the International Center for Alternative Dispute Resolution at the ICC. This slide actually shows organically the ICC dispute resolution services. Mediation rules are administered by the ICC International Center for ADR, which is actually a separate body from the ICC International Court of Arbitration. I personally work with the ICC International Court of Arbitration. By being here today and presenting mediation actually illustrates the synergy now between mediation and arbitration. And also attests also this orientation to extend dispute resolution services beyond arbitration and mediation, that we do have the same set of rules now in the same booklet since 2014. Just to give you some context and to share some statistics, this is the 2018 International Arbitration Survey conducted annually by Queen Mary University. And we see here that when users were asked what is the preferred method of resolving cross-border disputes, at the top, international arbitration together with ADR holds the greatest share of the pie. Then international arbitration, and then cross-border litigation together with ADR and cross-border litigation. This illustrates that also mediation is becoming part of this comprehensive dispute resolution process. To understand further these statistics, we went to a breakdown of the users who were surveyed, and this actually gives us even a better perception. When we break down the users between private practitioners, arbitrators, and in-house counsel, we see that the greatest share goes for the in-house, obviously. So arbitrators are maybe not big fans of mediation, but mediation appears to be quite valued by in-house counsel and the user. And this is also a telling fact that is, can be, when we read the survey. Also, some statistics. The cases filed with the center in 2017 made the center provide different dispute settlement services, expertise, dispute boards, and doctex, but mediation still holds the greatest share of services provided by the center. So mediation. Mediation is a flexible settlement technique conducted privately and confidentially. Now, confidentiality is a key feature of mediation with flexibility. Confidentiality means not that, it does not mean that the fact that the mediation occurred is confidential, no. What is confidential, it relates to all documents, any communication, any statement made during the mediation or in relation with the mediation cannot be produced as evidence in any other litigation proceedings, whether arbitration or court litigation proceedings. This also extends and applies not only to exchange of documents, but also to any views, to any suggestions, to any admissions made by one or other party during the mediation process. And this is crucial, because this will help to create a safe environment for the parties to negotiate, to open up, and to reach a mutually amicable settlement, knowing that failing that settlement, they will be able to start from square zero. The mediation process, the key person is a mediator. He acts as a facilitator between the parties to help them to reach a mutually accepted solution. This is a distinctive feature of mediation, and in a sense it differentiates it from arbitration, that the parties have full control on the process. They have control over both the decision to settle, and once they decide to settle, on all the terms of their decision, the decision they reach. And this also has very positive outcome to the process in terms of enforceability, because it's a solution, it's a decision, or settlement that was mutually accepted. So it decreases the risk of unenforceability that we might encounter in other dispute resolution settlement, like arbitration, where the solution is imposed upon the parties. This is also an overview of the origin of the parties and the geographic distribution internationally. Americas holds 41%, followed by Europe. We see that Africa has a full share in the pie, and this is actually a bit surprising, because these countries, African countries, Asian Pacific countries, they are known to have a mediation tradition. However, we do not receive mediation cases filed originating from these countries as to the same proportion that we receive from the Americas and Europe. Again, mediation is increasingly being seen and approached in international transactions where we have international parties involved from different legal background, different nationalities. The economic sectors featured in mediation, at the top we see energy, telecommunications, construction, followed by industrial equipment, and this is not surprising. In those sectors, we are in presence of long-term contracts, where the parties also are keen to preserve a long-standing relationship. So practically, how is the procedure, how is it conducted? The mediation request form is a form that the party would file with the International Center for ADR. In most of the cases, both parties have agreed, there is a pre-existent agreement to go for mediation. It's just a form, it's not a mandatory form, but it's a practical tool and it's user-friendly. This will allow the party to anticipate questions regarding their procedure. And they're not obliged to use the template. Again, flexibility is a key feature. The request will be filed with the International Center, and then once it is received and the filing fees are paid, an official acknowledgement will be sent by the center to the party. And the International Center will invite the parties to provide their comments regarding any outstanding procedural matter, the time, the place of the mediation, the attributes of the mediator, any procedural question that needs to be settled. A preliminary deposit will be made to cover the cost of the mediation, and then the appointment of the mediator, either by agreement of the parties. Failing an agreement, the court, the International Center of Arbitration will appoint a mediator. The file will be transferred to the mediator, and he will be invited to conduct the parties. The parties will have a first meeting with the mediator, following which he will be sending them a mediation note. In the mediation note, all the procedural issues will be clarified with the parties regarding the timing of the mediation, regarding the conduct of the mediation, and normally it will take 1 or 2 or maximum 3 physical meetings. So mediation is quite an express dispute settlement mechanism. Either it flies or it doesn't fly. And this is actually what makes it efficient time and from a time and cost perspective. So it might be not adequate to all disputes. We know that. But when it is adequate to a specific dispute, it's actually the preferred mode because it saves you cost, money, and time. And again, I don't have the slide, but if you look at the 2018 survey of Queen Mary University, when users were asked about the main features that they value in arbitration, at the bottom you would see time and cost. So this is where we see the competitive advantage of mediation. Back to the procedural steps. So following the mediation will take its life, they will have 2 or 3 meetings, and then either they will reach a settlement or they don't. When they reach a settlement, they will sign the agreement, and they will settle all the financial matters. The model clauses. In the guide, you will find the ICC model clauses for mediation. You will find 4 types of model clauses. 2 of them are a combination of mediation and arbitration. So here you have a sort of ascending bottom-up binding effect. Mediation and arbitration can be used successively, or they can be used simultaneously, actually, in parallel of an arbitration proceedings. And then the parties can agree to the obligation to consider using mediation, so it's not mandatory, or the least binding, which is a bit, I might say, useless, possibility of using mediation in the contract. This is a template met-arb clause. It's a multi-tier clause, and it's interesting in the sense as it provides for a time limit for the parties to conduct the mediation. At the expiry of this time limit, they will resort to arbitration. It is interesting with respect to mediation to determine the date of commencement of the mediation process. The date of commencement of the mediation process is deemed to be the date of receipt of the request. However, there is an exception to this rule, and this is the exception. When we have a multi-tiered clause, where we have a fixed time limit for the parties to reach a settlement at the end, at the outcome of the mediation process. The date of commencement of mediation will not be the date of receipt of the request, but the date when the acknowledgement is sent to the party, or when the filing fees are paid, whichever later. Why is that? To avoid that the party jeopardizes the whole period, files a mediation request, doesn't pay the fees, and completely paralyzes and defies the purpose of the clause. This is a very valuable tool. So aside, we have the rules of mediation and arbitration, and we have the mediation guidance notes. And this is a very user-friendly guide, even for people coming from a non-legal background. And it's a quite useful tool, actually, for in-house, for counsels, and even for business professionals. This is our contact, and actually the main contact, unfortunately, is not here. She is Alina Leonovo. She is the head of the International Center for ADI in Paris, and I'm happy also to put you in touch with her for any request regarding mediation services. Thank you.
Thank you very much, Tanya. Now we can have the Skype call with Judith, because she said that she wishes to listen also to your presentation, Janet. All right, so just a minute. I think so.
They worked this morning. The roundtable in the case was this morning. This is just a symposium in town. So they did it.
Hi, Judith. Good afternoon. Hello. Hi. We cannot see you. All right. Now we can see you. Thank you very much. It is turn for Janet to give a presentation, and then we will put you on screen when your turn comes. Is that all right? So you can listen to us.
I just like to listen.
Yes, thank you very much. Okay, so we can go ahead.
Well, now I'm sufficiently nervous that Edith has decided to call in just to listen to me.
It was overrated.
So this is very exciting for me, actually, and it's truly a pleasure to be here with all of you this afternoon. And I just want to thank again Dr. Maria, Dr. Pasquale, Professor Brand, and RUW and Professor Mona as our hosts for having us here this afternoon. And a special thank you to Professor Brand, because he was kind enough to leave out in his introduction when he discussed my background, but I'll go ahead and disclose it now, that I was his student in law school at the University of Pittsburgh, and he taught me how to argue a case at the Bismuth regarding international commercial arbitration. And so there's extra reason for me to be nervous this afternoon, because my teacher and professor is watching as this goes on. But I will do my best to get us from point A to point C, as I like to say to the students who have been working hard to prepare for you outside. So I am coming to you from the Singapore International Dispute Resolution Academy. We're a research and development organization based at the SMU School of Law. Actually, that will be official as of April 1st. So we will have a brand new parent at that point, and we will be a research institute under the University Law School. And my job there is to manage the programs and learning portfolio, and that means that I also get to interact quite a bit this year with one of the most exciting developments to come out of the international dispute resolution landscape in 2018 and 2019, and that is the introduction of the UN Convention on Enforcement of International Settlement Agreements resulting from mediation. But we can shorten this, as the General Assembly at the UN agreed, to calling it the Singapore Convention. So I'm very happy to be the delegate from Singapore today. and I'll briefly go through just a little overview of the convention, including its main features, the impact that we may expect it to have on the international dispute resolution landscape more broadly, and I'll briefly look at the question of what would it take for a jurisdiction to be convention ready if they wish to join the convention or adopt it in the future. So moving right into the first bit, and I'll just preface briefly what I know Judith is going to address during her presentation, which is that when Working Group 2 negotiated this instrument, they didn't only create a convention, they actually negotiated and drafted 2 documents, creating a whole new legal framework for the settlement and practice of international mediation, cross-border mediation. And so they, in addition to putting together a convention, they also drafted a model law, and Judith will be discussing that in more detail. For the purposes of my presentation, I'll just focus on the convention for now. And I'll start by posing the question, which is why have a convention on mediation at all? After all, enforcement is not considered generally to be necessary with mediated settlement agreements, considering that compliance with mediated agreements tends to be very high. And as was pointed out, there are already mechanisms and protocols for enforcing mediation in cross-border scenarios through other means that institutions provide, such as the ICC in a med-art situation. So the question we should ask ourselves is why have a convention on this topic? Well, as it turns out, the use of mediation as a standalone cross-border dispute resolution method was under threat. And there's reason to believe that without an international enforcement mechanism, it wouldn't be possible to promote mediation as a standalone dispute resolution process which could grow on its own. And therefore, UNCITRAL took up the work of promoting an instrument for the enforcement of these means or these goals. And the primary goal of the Singapore Convention is therefore to promote the growth and development of mediation in the cross-border context. The convention is designed to provide an expeditious and clear enforcement mechanism for parties who wish to avail themselves of what is thought to be, it turns out to be, quite a low cost, effective, and faster form of dispute resolution than much of what is available through arbitration and international litigation. And with the benefit of a convention, this comes without the associated risk of an opaque or non-existent international legal framework for enforcement. So the Singapore Convention, in essence, provides the stamp of approval similar to what parties have come to rely on and recognize through the New York Convention when they're engaging in arbitration. So to briefly examine the main features of the convention, I'll go through each one in turn, which are scope, the mechanism of enforcement itself, the requirements for an international mediated settlement agreement, the grounds for refusal of enforcement, and any permissible reservations under the convention. So under Article 1, the scope of the Singapore Convention applies to commercial cross-border agreements resulting from the mediation and concluded in writing. The term mediation under Article 1 is to be interpreted broadly, and this may include any process through which the parties sought to resolve a dispute with the assistance of a third party who lacked the authority to impose a resolution or a solution on the parties. The next requirement is that the settlement must be international in nature at the time of its conclusion, which means that at least 2 parties to the agreement should have their place of business in different states, or the states in which substantial obligations are to be performed, or to which the subject matter of the settlement agreement is most closely related, which is a topic of much.
The weight of expectation is not shouldered by judges alone, but also by the legal profession. And then, of course, I ask myself, what is the forum for this discussion this afternoon? Well, why? It's a discussion derived from academic journals, and here we are in the body of the university in a research symposium. So it seems to me that one's adding in elements, not just the judiciary, not just the legal profession, the academic world as well. Moreover, the original watchspring for any UNCITRAL compliant arbitration law lies in policy choice to follow that route. Going back to what UNCITRAL itself had said, the UNCITRAL model law provides a pattern that lawmakers can adapt. So we have a fourth element to consider. It's therefore vital, in my view, to recognize that the grand endeavor inherent in the model law requires true cross-sectoral collaboration, combining the academic with the practical, the legal profession working with the judiciary. And having noted the breadth of the context in which it's rooted, let me now return and say a word or two about judicial internationalism. Let me begin by posing a question, and I've already said I can ask more questions than I can answer, or that I need to answer. So here's the question. Should a court, the court, adopt the same approach to interpreting and applying an UNCITRAL model law compliant arbitration law as it does to other, in inverted commas, ordinary domestic legislation? Of course, the arbitration law is part of the domestic law, but should the same approach be adopted? And in my view, the answer is a resounding and unequivocal no. Now, of course, you could say, well, that's obvious, because the point was put beyond doubt in the 2006 amendment. You don't need to look beyond Article 2A, which was included in 2006, and has provided that in the interpretation of this law, regard is to be had to its international origin and the need to promote uniformity in its application. When you look at what Professors Bachon and Guélinas were saying, however, they view the 2006 amendment simply as having made express that which was always implicit. In their view, it is not that the courts may depart from interpretive models that they usually use and have resort to, but rather that courts must do so, because in their words, because treating the model law in the same way as other statutes risks undermining the fundamental policy choice reflected in a state's decision to incorporate the model law successfully. Again, one sees that the linkage of the discussion includes very clearly policymakers as a component part. Indeed, the policy considerations can be traced back even further to the drafting of the model law, as was pointed out in a judgment of the Bermuda Supreme Court in the matter of Montpellier Reinsurance in 2008. The judgment contained the following paragraph. The model law must therefore be construed in a distinctive way from the approach that would be adopted when construing ordinary domestic legislation. It is essentially international legislation, the language of which largely reflects the compromises and negotiations conducted by expert representatives from a wide array of national legal systems. Not only is the model law international in character, giving rise to the need for a distinctive interpretative approach, but Article 5 of the model law provides that supervising courts only have such powers as are conferred by the model law itself, depriving this court, i.e. the Bermuda Supreme Court, of the popular common law resource of general jurisdiction. Now, obviously, a substantial challenge confronts the judiciary and the legal profession alike in the effective implementation of an UNCITRAL compliant arbitration law. As the authors to whom I've already referred rightly observed, the harmonization purpose of the model law would best be achieved if all judges thought like international judges, one might add, and if all counsel thought like international jurists. There are, however, some guiding principles for judges who are called on to make decisions about law that is based on principles with which they are themselves not necessarily familiar. Vachon and Galinas recommend that a judge should adopt a two-stage process, asking first if there is international consensus on the point. Look internationally, not domestically. If there is international consensus, that should be determinative. If there is not, then the judge's task should be to identify what would be internationally acceptable. And one can draw on guidance from the Vienna Convention on the Law of Treaties. I accept immediately that the model law is not a treaty, but one can borrow by analogy. One tool would be to remember that the model law has 6 official languages, including Arabic. So, drawing on Article 33 of the Vienna Convention, it's suggested that the judge should look for the solution that is most consistent with all of the official languages. Beyond that, the judge should consult the travaux preparatoires for the model law. Again, compare that with Article 31 of the Vienna Convention. A judge should also be, or would also be, well advised to cast a wide net in reviewing relevant case law. We have 100 jurisdictions that the judge could possibly consult and look at. And in that regard, Vachon and Galinas make the point that English law commentary on the model law should be treated with caution, because the English Arbitration Act 1996 had regard to, but is not based on, the model law. Now, I'm tempted to think that the professors being at McGill University, therefore a university in French-speaking Canada, may just have a little vested interest in saying what they said in their 4th point, but I'll let that one go by the by. Now, all of this, certainly if you're looking at it from the perspective of a judge, sounds like a lot of work, and there is undoubtedly considerable effort in what I think judges must do, namely walk the walk. But that said, there are resources to help, and let me identify 3. There is the Internet Accessible Portal for case law on uncitral texts, abbreviated to CLAT. Other academic databases and resources, for example, the McGill Model Arbitration Law Database, and finally the bibliography of recent writings related to the work of uncitral, the uncitral bibliography, which uncitral itself publishes. Let me conclude by drawing the strands of my presentation together. How can jurisdictions with an uncitral compliant arbitration law, especially jurisdictions with a newly enacted law, walk the walk and not just talk the talk? There are, as I've sought to identify during the course of my presentation, 5 constituencies that need to be considered. The policy constituency, the judiciary, academia, the legal profession, and the international business community. In my view, and this is the culmination of what I've said so far, there is enormous value in cross-sectoral collaboration between all of those constituencies, or stakeholders, if you like. The policy choice, in one sense, has already been made, but there is an enduring interest amongst policy makers in the effective implementation of that choice. The judiciary and legal profession are weighty components in the equation. The legal profession should shape the arguments of the parties that they represent. They should shape the parties' arguments and submissions to promote and facilitate that judicial internationalism to which I referred. The judiciary should be both mindful of their obligation to apply an internationalist approach and fearless in doing so. Where internationalism and domestic analysis diverge, judges must be courageous in following the internationalist path, even if that is counterintuitive from a domestic angle. And the legal profession must be equally fearless and courageous in supporting the judiciary in pursuing the correct path. Academia is, in my view, in a unique position, both to provide a forum for discussion, as indeed is exemplified by this research symposium, but also to coordinate mutually beneficial liaison, discussion, interchange between the stakeholder groups that I've identified. Academic institutions like the Royal University for Women in Bahrain can, and I venture to go so far as to say should, take the lead in this discussion. Finally, the international business community is, of course, the consumer, the user of the international commercial arbitration system. The business community is an extremely knowledgeable and sophisticated community. The discussion must include the business community, and it must include the business community at C-suite level and at general counsel level. So, academic facilitation of the dynamic process that I have just described will, in my view, make an invaluable contribution. And that is my limited and modest proposal in the context of this first research symposium for a topic to take forward. Thank you very much.
So we move to the next presentation.
Well noted.
So Professor Zlatan with the presentation on choice of law governing the arbitration agreement. First or less.
Well, while it's being established, I will use the opportunity to thank the Royal University for Women for inviting me. It is a great pleasure. I mean, at the first research symposium and in such a panel and with this audience, it's obviously a great honor, and I'm really thankful for this opportunity. And I want to emphasize that my topics will go back to a little bit to what you heard this morning and what you hear in the next 2 days in various versions. And that is the applicable law to the arbitration agreement. In particular, of course, I didn't want to make the argument instead of the students, but I took a different approach. And I asked myself, as a researcher and as somebody who's teaching private international law for 11 years now, should somebody choose the law governing the arbitration agreement? Is it a curse or a blessing? And while asking that question, I want to announce what my opinion is before I then try to prove it. I think it's a curse. I think nobody should do that. And I also think that here the private international law and the arbitration law disagrees. And the private international law professors consider arbitration law to be a part of the science of private international law, but they often collide at certain points, and that's why I took this topic to show. However, I will start by opposing to myself and telling you the arguments why somebody would maybe choose the law governing the arbitration agreement. And that is basically legal certainty. Why legal certainty? Well, then the arbitral tribunal should not ask itself what law should govern the arbitration agreement. You have a choice of law, and if it's done properly, the emphasis on doing it properly, then you don't have any other problem. The other thing is that you might want to create uniformity with the law of the seat or with the law that governs the substance of the agreement. So if you don't want the arbitral tribunal to have this choice whether it will apply the substantive law to the contract or the law of the seat, then you simply choose one of those and you do it properly again, and then you don't have a problem, because then the arbitral tribunal needs to follow this. So in general, choice of law is considered in private international law to be a very simple connecting factor. We talk about connecting factors in choice of law clauses that can be like, I don't know, the domicile, the nationality, or whatever, and here it's the choice of law as a connecting factor. It's very simple because if somebody just writes down, I choose this law, and then you know, okay, this is the law that needs to be applied. And these are all advantages if done properly. What questions could then be governed by this choice of law? Well, all sorts of questions. When you talk about arbitration agreement, it always seems so narrow because nobody thinks about all the variety of issues that could arise. But it could be substantial validity, it could be the form. It can be even, for example, a question that arises in Bosnia and Herzegovina a lot. Can the arbitration agreement be concluded in general terms and conditions? Because that's like a usual way to do it for big companies. And also, what is the case in this year's problem, what is the law applicable to the interpretation of the agreement? And that is something which can be covered by the law chosen by the parties. So all of these issues could be then governed by the law. Well, under private international law, we don't consider that choice of law is a given, that you can simply choose a law whenever you want to. So in family matters and succession matters, you often are not allowed to do so. However, we have a couple of instruments that tell us that you can do so. And although this is a relatively new issue, it seems to be modern again, because of the HKIAC clause and some other cases, to choose law to arbitration agreements. It's a relatively old issue because this was already in the New York Convention. There is a conflict of law rule in the New York Convention stating, yeah, you can choose law for substantive or formal validity. The same is true for the European Arbitration Convention, for example, which applies in Bosnia and Herzegovina, which has, in my view, the best conflict rules for this. But also the Hague choice of law principles, which are somewhere adopted, could be potentially applicable to this issue. The major case law here is the South America case for the common law countries, but also for arbitral tribunals who prefer case law over legal acts. I'm coming from a civil law country, so I like to have legislation. So, in general, why would you do it? Well, in order to know why you would do it, you need to know what would apply if I don't do it. Okay? So if you want to choose law, you should first ask yourself, if I don't choose law, what would be applicable? And the private international law would say, well, under the New York Convention and under all of these international rules, it would be the law of the seat that is applicable if you don't choose law. So the law of the seat would, without any choice of law, be applicable, and since the connecting factor would be the law of the seat, it would lead you to the legal order of the law of the seat as a whole. As I said, there can be various aspects of arbitration agreement that could come into question. For example, did the parties have the capacity to sign this agreement? In Bosnia and Herzegovina, this question is regulated in family law. So only our family law regulates capacity of natural persons. So it can be substantive or procedural law that applies to various questions of the arbitration agreement, and this is not unusual. So the whole legal order of the seat of arbitration would then apply if you come over the seat of arbitration as a connecting factor to the applicable law. And if you don't like that, if there is something better in the chosen law, then you should choose the law. That would be the obvious then advantage. You need to have a motive to choose the law, which you could do by simply choosing the green one, which is the law applicable to the substantive matters of the contract. That would be like the second best option then. Or you can choose a third law, so that you have the law of the seat as lex arbitri, then you would have the law applicable to the substance, and then you will have a third law, which would be the law applicable to the arbitration agreement. We can only say good luck with that. So if you don't look at it from a private international law perspective, you'll hear many arbitrators tell you this. No, the seat of arbitration is just the lex arbitri, it's just procedural law. So even if through the connection factor of the seat of arbitration you come to the actual seat, it shall apply only as lex arbitri, which would mean only as procedural law. And they would probably join the substantive law which is applicable to the contract, filling gaps to the lex arbitri, which from private international perspective would be wrong. because you apply the legal order as a whole whenever you reach to a connecting factor, the law of certain country. And this is the basic disagreement. However, you need to be aware of that in that case, if that is what would happen, and that when you want to choose law, you should know what would happen if I don't choose it. If that is the case, if this arbitral tribunal will come to this conclusion, then you have to be aware why you would or you would not choose the law. So this is like the neutral argument. This is what would happen without choice of law. And if you think that this is complicated, you'll hear more complicated arguments tomorrow. However, it is the question of the applicable law to arbitration agreement is a challenging one for various reasons. Another thing which is now I come a little bit so I came from the positives a little bit to the negatives, and that is that you can choose, according to the prevailing opinion in the science and various arbitral awards, such as Sul America, you can choose the law also implicitly or impliedly. This creates, of course, great uncertainty, because it seems to me that sometimes the arbitral tribunal has a tendency to say that parties wanted to choose the law, whereas actually it was never the intention of the parties to choose the law. The parties have chosen the seat of arbitration. Does it really mean that they wanted to choose law? There were certain circumstances around the case which are objective circumstances, but that was not the will of the parties. So whenever investigating whether there's an implied choice of law, I would say that you need to be really careful and look at the contract, because the contract shows the will of the parties. So the basic example of an implied choice of law would be, for example, if you don't explicitly choose the law, but you say you refer to certain legal institutes of that legal system, or you refer to something specific about that legal system in the contract, so it makes you aware that they actually wanted to do it. Just choosing the seat doesn't seem very convincing, because in many cases you'll have a choice of the seat without actually having a choice of the law. So another thing why private international lawyers don't like when the choice of the seat is considered to be a choice of law is because in that particular case it would mean that the arbitration tribunal always applies its own law. And private international law loses its purpose if nobody applies foreign law. That's why in private international law, whenever you choose certain jurisdiction, it should not be considered that you have chosen the law, otherwise everybody would apply just its own law. And private international law, we can all go home and not be professors anymore. So
some people wouldn't care.
Some people wouldn't care. So what is again the argument against the choice of law? There are many things which are considered to be mandatory provisions in national law, such as arbitrability, such as public policy, scope of the arbitration agreement, powers of the arbitration agreement. Many things are under national arbitration law considered to be so important that the choice of law cannot derogate them. We call them overriding mandatory provisions or mandatory provisions of national law. And even so, private international lawyer would do it in a way that when you choose the law, you can never have the law which overrides overriding national provisions, which would mean that you would combine these two. You would apply the chosen law to the extent as it doesn't violate the national provision. So you would have like a mix of these two legal institutes. However, it seems to me that in arbitration the tendency is more like I will try to apply the law and interpret it in a way that it doesn't violate national law, because otherwise it would endanger enforcement. So it comes maybe to the same result, but it's not really the same because you don't apply the two laws. You apply one law, but you interpret it differently, which can also be a way of doing things. However, you need to be aware that the choice of law cannot derogate the whole arbitration law, so that's the purpose. So, why should not the parties choose law governing the arbitration agreement? Well, first of all, it needs to really be well drafted, and unfortunately there are a lot of poor contracts around, and it can complicate things. If you have 1, 2, 3 legal orders which are in question, and somebody has a badly drafted contract, and there's some ambiguous choice of law clause, it can really complicate things for the arbitral agreement. So the chosen law will only apply insofar as it doesn't violate mandatory rules. Of course, we would not have this problem if there would not be a possibility to choose the law. It is not very usual. It is not very usual. It is in arbitral proceedings in the sense that you choose the rules, but it's not very usual that to certain things you can actually choose the national procedural law to apply to something that is quite unusual in general practice. So the arbitration agreement is one of the few examples where you can actually do that you choose national procedural law to apply to something in the contract. So it seems that it's, that's why it runs this danger of violation. And you have to take into consideration what Michael Joyce was just stating. The courts, I mean, we can wish that they're internationally thinkers and lawyers and judges, but in many cases they're not. So the arbitral tribunal will think more internationally, whereas the court reviewing this award will not think as internationally as it would. So that's why recommendation. I'm stating just that the easiest way to deal with this is if you choose the law governing choose the law of the seat to govern the arbitration agreement, and then you don't have any problems anymore. You're basically doing the same as if you had no choice, because that would be the law that would govern it anyway. Unless there is a very, very good reason why you want to go away from that law, but being aware of the mandatory provisions that you cannot override, then you need to have a certain purpose. And if it's not the chosen law, neither governing the substance or the seat, then if you're introducing a third law, well, you want to wish that you have somebody on the panel who knows private international law, because otherwise you will have three laws and a very complicated issue, and then somebody at the court reviewing this award who will be able to follow what the arbitral tribunal has actually stated. So that's why I'm skeptical of this choice of law, and let's see if the students can be persuaded to otherwise. Thank you very much.
Professor Brand for his presentation, Understanding Forum Differences for International Commercial Dispute Resolution. Professor Brand. Please.
Okay. I am fully aware that I am the only person that's standing here between you and a pleasant evening in Bahrain. All right. So I'm going to try both to talk about something that I hope will keep you awake and might also be interesting. Now, I want to deal with forum differences, understanding forum differences for international commercial dispute resolution. We've heard about mediation. We've heard about arbitration. I'm going to throw something else into the mix. I'm going to throw litigation into the mix. When I teach these kinds of issues, when I teach choice of forum and choice of law, I teach it most often, I do teach international commercial arbitration, but I also teach international business transactions. And I tend to come at these things from a transactions perspective more than a dispute resolution perspective, because I think the ultimate test of a good legal rule is, does it allow you to draft clearly and easily and reasonably within the rule to get the results that parties would like to have. Now, if we think about arbitration, okay, it begins with consent. Consent requires a contract. Contracts present choices, and that's exactly what Zlatan has been talking about. Now, I'm going to talk about some of the same choices he's talking about. And I don't necessarily come to the same conclusions, but I do come to the same conclusion about the complexities of the intermix of private international law and arbitration clauses. But dispute resolution lawyers depend on the choices made by transaction planning lawyers, right? If they're bad choices, dispute resolution, if the transaction planning lawyer makes bad choices and does poor drafting, the dispute resolution lawyer makes a lot of money. right? And so maybe dispute resolution lawyers should hope for bad drafting, but I don't think that is what we should do as members of the profession. Now, we've talked about the international rules for arbitration, primarily the New York Convention, but also the UNCITRAL model law. But there is a context for applying those rules, and part of that context is private international law and the traditional rules dealing with, in particular, applicable law. But I'm going to go into another area of private international law. The three pillars of private international really are jurisdiction, applicable law, and recognition and enforcement of judgments. Okay? We've talked about applicable law, but jurisdiction is important too. And jurisdiction means who has the ability to decide this case. And we've talked about two legal instruments, the New York Convention and the Singapore Convention, but there's one other that's in place and another that's coming that are important that you understand because they're part of the choices that are available to the transactions lawyer. One of them is the 2005 Hague Convention on Choice of Court Agreements. And that convention basically does for choice of court what the New York Convention does for arbitration. Okay? And I'm going to briefly take you through that. There is also being negotiated at The Hague a second convention that is the non-consent convention on recognition of judgments. And that moves to a diplomatic conference this summer in late June and early July, and if that conference is successful, there will be a new convention on recognition and enforcement of all judgments other than those resulting from exclusive choice of court agreements. But the one that really meshes with the New York Convention is the Choice of Court Convention. Now, each of these treaties presents choices. They present choices to private parties. They present choices to governments. Okay, choices to governments in the process of becoming a party of ratification include the kinds of declarations that can be made, and the choices that can be made. New York Convention, done in 1958, now has 159 parties, an incredible success. Okay, and that's why arbitration works. It's why arbitration clauses are in contracts. If you ask transactions lawyers, why did you put an arbitration clause in? They will say, because of the New York Convention. Okay, because I know that I can get the agreement enforced under Article 2, I can get the award enforced under Article 3, subject to Article 5. Okay, and let's take a quick look at that then. So Article 2 creates an obligation on states to recognize an agreement, and paragraph 3 says all contracting states, when there is such an agreement and the case is brought to court, shall request of one of the parties, refer the parties to arbitration. Now in the Federal Arbitration Act in the United States, it's even much stronger. Not just refer the parties to arbitration, you shall compel them to go to arbitration. Article 3 Article 2 is the jurisdictional rule. Article 3 is the recognition rule. So those two pillars of private international law, other than applicable law, come in here. And it's a simple rule. Contracting states shall recognize arbitral awards and binding. Okay? That's a simple rule, subject to Article 5. Very, very limited grounds for non-recognition of the arbitral awards. Okay? Now, if we go back, however, and here's what I think is kind of interesting in the New York Convention is the distinction between Article 5 and Article 2. If we look at the Article 5 grounds for non-recognition of the award, they're very different than the grounds for non-recognition of the agreement, okay? And for example, there is no public policy exception to recognition of an agreement to arbitrate. Nobody can say enforcing this agreement violates public policy because the New York Convention doesn't tell you you can do that. Only if it's non-arbitrable, and that's something that's been developed in its own context, or it's null and void, inoperative, or incapable of being performed. Those are very limited grounds, okay? But very much more limited than the grounds under Article 5 for non-recognition of an award. All right, now, the Singapore Convention. Now, the Singapore Convention doesn't have a jurisdictional, because it doesn't make sense to have a jurisdictional provision. It only has a recognition, or in the Singapore, as we were told earlier, not a recognition provision, an enforcement provision, and they chose to move to the term enforcement. Each party shall enforce a settlement agreement in accordance with its rules of procedure and those conditions laid down in the convention. I think that's a very good thing. I think that's going to make mediation much more palatable for a lot of people. And if you think about it, you think, well, what the heck? If it's a consensual agreement, then they're going to comply, right? Because they've consented to it. That's very different from an arbitral award where it's been imposed upon you by a third party. And the answer, to me, the Singapore Convention is not so important because it will mean that settlement agreements do get enforced. It's important because parties will realize that if they go to mediation and the settlement agreement is not complied with, they can enforce it. Therefore, they will be more likely to use mediation, even though no enforcement mechanism at the end is probably going to be required. I think that's important. Now, the Hague process and the Hague Choice of Court Convention, the process began in '92. There was a long process where it was going to be a very elaborate convention, like those of you who were on the Brussels I regulation in Europe that deals with jurisdiction and recognition, enforcement, and judgment. We were going to unify jurisdictional rules for the world. We figured out they can't do that, or at least we couldn't do it in 1999, 2001. I don't think we can do it now. So we cut it back to where I think it should have started, to something that gives transactions lawyers clear leveling of the playing field with arbitration. And that's what we got in the Choice of Court Convention, which was finished in June of 2005 at a diplomatic conference. That convention now is in force. The European Union, which has exclusive competence for these matters, has placed it in force for all of its member states. Right now that includes Denmark, who has special treatment, in the UK, at least until the end of this month, but the UK has even filed a specific statement that says even after that, if there is a Brexit of some sort, if it happens,
2 more months.
They will continue to be a party to this convention. Mexico, Montenegro, and Singapore have, and Singapore is important in that, are also parties. China, the United States, and Ukraine have signed. In the United States, we have a huge political problem on how to implement it. Everybody agrees it's good law. We should have it, but the Uniform Law Commission wants to implement it by state law, which would be, we can, if you would like to have a long discussion, we can do that over liquid refreshment sometime later. What does the Hague Convention do? It parallels the New York Convention. Rule number 1, jurisdiction. Courts designated an exclusive court agreement have jurisdiction. Rule 2 is, but you need a second rule on jurisdiction in this, because a court not chosen shall decline to exercise jurisdiction. And rule number 3, but here we have what you see is more grounds for the court not to recognize the agreement than you have in the New York Convention. Okay, more exceptions to that obligation. Rule number 3, a judgment resulting from that choice of court shall be recognized and enforced. And then in Article 9, what we have are basically the same sorts of grounds for non-recognition as you see in Article 5 of the New York Convention. So I'll come back to that. There's an optional 4th rule that would allow for circulation of judgments that result from non-exclusive choice of court agreements, but I won't get into that. And there are exclusions and limitations. Now, in the United States, I've mentioned that there are political problems. There is what I call the contract to dispute time gap. This is like when you create a new arbitration institution. You know, they sit around and wait for somebody to put it in their contract, and they wait for a contract that has it in to turn it into a dispute so they can get some business. It takes time. There's lead time. And we've got the same issue with the convention. But here's something different. The opportunity for sovereign entrepreneurship. What's going to happen with Brexit? You know, London has been a magnet forum. Will it continue to be a magnet forum when we have Brexit? Well, there are a lot of countries that are trying to replace it. Singapore, the Singapore International Commercial Court, Dubai International Commercial Court. There have been created new commercial courts in Amsterdam, Brussels, Frankfurt, Paris, and other places. governments are being like arbitral institutions. They want to get the business. They want to get the litigation business because they know that it's good to have lawyers in their country making more money because then they can get more in taxes and it's good for their economy, right? So what's going to happen to the existing magnet courts in London and the Southern District of New York? Who knows? We'll see. Interestingly enough, though, most of these new magnet courts hear cases in English, but for example, the one in the Netherlands, you can bring your case in English, but if you want to appeal, you have to do it in Dutch. It's really kind of an interesting concept. So comparisons, how level is the playing field? If you look at it very briefly, what you see here is the basic rule under agreements to arbitrate are honored under the New York Convention, choice of court agreements are honored under the Hague Convention, but the exceptions differ somewhat. Okay, very much more limited under the New York Convention. The recognition of the decision rule, arbitral awards will be recognized, judgments will be recognized, pretty much similar. Okay, but you see what really has happened is for the transactions lawyer, the playing field has been leveled. You cannot just simply say I choose arbitration because of the New York Convention. If the Hague Convention becomes widely ratified. So you can still say it now, but transactions lawyers are going to have to make more informed, more complex decisions. There are also decisions on declarations for states to make. Declaration. The United States has made this one that it recognizes awards made only in the territory of another contracting state. With 159 contracting states, that's not tough. Only commercial cases. There are some differences. Now, what does this mean to drafting? Well, it means you have to think of 5 different issues: consent, formal validity, substantive validity, scope, and exclusivity. And in the drafting, you can deal with each of those. There are non-drafting issues because you can bring in courts certain types of cases you can't bring in arbitration, and particularly if there's the possibility, and you all know this, if you have multiple parties, it's much easier in courts than it is in arbitration. Okay, and right now, again, New York Convention leads us to favoring arbitration. The Hague Convention might give us balance. There are lots of advantages to arbitration, but it's not always the best choice in some contracts. A friend, when we negotiated this, called it the middle class convention, because arbitration for smaller cases just doesn't make sense. But we should have lawyers making informed decisions. These issues of consent, formal validity, and what we could do is go much further and talk at the next question is what law governs each of these. And different law can govern each of these 5 issues in the choice of forum clause, whether it's arbitration or litigation. And so, I've tracked through that here, but I realize we're running out of time. And so I'm going to move forward on that just to this. Consent, existence, that question is not a question in the New York Convention or the Hague Convention. It's not a question governed by the UNCITRAL model law. That's a matter of substantive contract law. Now you can put in your clause, this arbitration agreement shall be governed by the law of X, and that would include that gets you to the contract formation rules and whether you have a meeting of the minds. Formal validity, that is governed by arbitration law and by the Hague Convention. Substantive validity, well, there is a rule on that, null and void, but you have to look to the law of a state to determine whose substantive validity rule applies. Scope, that's an interpretation provision. In the VIS problem, that's an Article 8 CISG issue. Exclusivity, how exclusive is it? That, again, that's in the VIS problem this year. That's a question of interpretation. However, in the Hague Convention, there is a presumption of exclusivity if there is a choice of court clause. Okay? So each of these issues is important, but you need to be aware of the governing law and the resulting rule regarding each issue, and the words which will produce the desired result. And I might add, you must, party autonomy, you must be aware of whether the rules allow you to change the default rule, and those are the mandatory rules, and there are certainly limitations on that. So I hope I'm a little beyond the time we'd originally scheduled for, but I hope that hasn't prevented you from having a wonderful evening in Bahrain. Thank you.